Now, in oral argument, the appellants seek to revive their line that none of the information requirements in section 38.3a to G were complied with, despite the fact that this was not referred to in their heads of argument. Again, there's no substance to their submissions. May I take your ladyship now, I'm corrected by my learned junior, I think I referred to appellants. I should have said applicants. May I take you now to volume 5, starting at page 2138, milady. Here, the minister refers to the different subsections of 38.3, deals with them, refers to the heritage impact assessment and the other relevant documents, indicating that the information requirements in each was met. Paragraph 39 at page 2140 deals with the mapping requirement, and you'd have heard an echo of that yesterday. He points out that what Heritage Western Cape had contended is that the heritage specialists only partially mapped the heritage resources.
Sorry, which paragraph are you reading?
2140,
214.
paragraph 39. This is now dealing with A. The minister says that's not correct, and he refers to all of the documentation which is available in this matter, and says that the specialists provided maps of 3 separate mapping exercises. So A is complied with. He then deals with B, impact, in paragraph 41, referring to the source documentation, saying this is where the information is provided. He does the same with C. I'm sorry, I said B, I said impact. B is significance. C is impact. And you'll see that at page 2141, paragraph 42. D, which he deals with in paragraph 43, involves the impact in relation to substantive social benefits. Strangely, even that is persisted in today as somehow not having been complied with in a kind of a catch-all way. But there's nothing to it because it's there. And then E deals with a requirement to consider the results of consultation with communities affected. And it's necessary, my lady, to deal with this aspect in a little bit more detail. The first question one needs to ask is what case is put up in the founding affidavit in relation to section 38.3e. You'll find it in volume 1 at page 35. I beg your pardon, I gave you a wrong reference. 35 was the section itself with E. I've dealt with that. It's page 74. And your ladyship would recall that this forms part of the exercise undertaken by Professor London and whoever drafted his founding affidavit at the time, in which they tread through A to G and say that none of these are met. This is what we see under the heading Results of Consultation with Communities Affected and the like. It's page 135, paragraph 135.5. While the formal requirements of the Promotion of Administrative Justice Act 3 of 2000 were complied with, and we have this phrase, the consultation was not meaningful. Where does Professor London get this? He gets it from Heritage Western Cape, which he quotes, where it says, "It is clear to the HWC that there's been a lack or avoidance of meaningful consultation with the First Nations groups. HWC is further disappointed that in the instances where comment has been received, this comment has seemingly been dismissed as a difference of opinion rather than a meaningful interrogation of concerns raised." So, what does the founding affidavit then say? It says the formal requirements of PADGA were complied with, but one's left with the vague statement that consultation was not meaningful. To say that consultation is not meaningful does not involve providing any facts. It's the expression of an opinion. An opinion can only be based on certain facts, but the difficulty for the founding affidavit and for the applicants is that no such facts are put up. And there's a reason for that, because they have no facts at their disposal. All that they're doing is riding on the back of Heritage Western Cape. The response to this, you will see at page 2142, back to the minister's affidavit. Paragraph 45. In HWC's interim comment, it stated clearly that the formal notice and commenting procedure had been complied with, but that there had not been a meaningful consultation with First Nations groups. The specialists dealt with this criticism in the HIA supplementary report. An appropriate expert was found and engaged. Section 2 in the HIA supplementary report at pages 4 to 9 dealt extensively with the engagement of the First Nations people, and so on. So, and this was considered on appeal. So that is where this aspect ends with respect in terms of consultation. No facts are provided to support the statement to the effect that consultation was not meaningful. The oral notes and the oral argument attacked the First Nations report. It's already been dealt with by our learned friends for the first respondent, but the point that we wish to emphasize is that that only formed part of the consultation process. So the submissions that we hear relating to consultation simply don't deal with the response in the minister's affidavit. Now, my lady, you correctly, with respect, posed the question at times to our learned friend for the applicants. What is it that should have been done which was not done? It's a simple and direct question. Particularly in this regard, what case is made out in the affidavits relating to consultation? The case is flimsy in the extreme. Apart from the fact that insofar as it's put up, it's fully dealt with the minister, one's left asking these kinds of questions relating to consultation. What is your complaint? Are you saying that the first applicant was not consulted? No, they don't say that. Are you saying that the second applicant, represented by Mr. Jenkins, was not consulted? No, they don't say that. They say he withdrew. Are you saying that there are other people out there who were not consulted, but you don't name them? Are you saying that there's some other defect in the consultation process? For example, that it took place too late, or they didn't listen? You're not told. So, in this context, the submissions of the amicus relating to consultation will be dealt with later, but may I simply say at this stage what it amounts to? They're interesting but irrelevant. And also may ask this question: consultation on what? There's recognition across the board, as I've indicated, that this site has significant intangible heritage significance. This is accepted. You don't have to consult on that anymore. Regarding what to do, there's been a wide range of consultation. We've seen that. Are the applicants seriously suggesting that they wanted to be consulted on this notion that the state might expropriate the property? It's not put up in the papers. And with respect, it only has to be raised for one to understand that in this context, and let me not overstate it, it's highly improbable. We can have the state come along. As the law presently stands, they'd have to pay compensation for the property. They'd have to secure it against probable persons who might want to go and live there. They would have to rehabilitate it by removing all of the vestiges of colonialism and subsequent developments, and then they'd have to maintain it. It was never seriously suggested and can't be suggested now. On to the next point, and that is alternatives. You'll find the minister dealing with this in his affidavit at page 2142, paragraph 46. Under the development proposal, they say 5 development scenarios have been considered. These include the no-go alternative, a preferred riverine corridor alternative, an island concept alternative, and another 2 which are not financially viable. They go on to discuss this and summarize it in the executive summary, indicating why, in their view, the riverine corridor alternative is the better proposal. The body of the report dealing with this aspect is at 2514 to 2518, where the alternatives are explained. So the notion that alternatives were not considered and therefore the information requirement in 38.3f was not met is simply untrue. Likewise, Milady, mitigation, which is G, 2143, paragraph 47, contains the minister's response on mitigation. It's dealt with. And what follows after these paragraphs, Milady, is the reasoning as explained by the minister in respect of why he and before him the director thought that the riverine alternative, as further developed with the conditions brought up in the first place in the supplementary heritage impact assessment, was the preferable one. So, Milady, it's our respectful submission that when these considerations are taken into account, it will become clear that on the papers as they stand, the applicants have not made out a prima facie case at all for the review of the environmental decisions. At best for them, their case is open to serious doubt. The ladyship would have noticed that in the heads of argument, I'm talking about the real heads of argument, not the oral note, there were some remaining grounds that were dealt with, 3 of them. I'm going to deal with them in a moment, but I want to make the overall submission that these are just make-weights, some of which are of the type so often encountered in appeals dressed up as reviews. They're dealt with in our heads of argument from page 43, but let me simply sum up our submissions in respect of each of them. The first contention says that the minister's decision was irrational. It's dealt with in our heads of argument, page 44. The starting point in trying to assess this submission is, of course, the minister's decision itself. It's in volume 6. It's Annexure AB1. I'm going to ask your ladyship to go there. Condition E9.1, stormwater management. Condition E9.2, a rehabilitation restoration plan for the rehabilitation of the Lesbia Canal. He's applying his mind to it. He then deals under E, I'm at page 2199, with the conditions which are to be applied. And then starting at 2200, he sets out his reasons. He refers to the reasons for the environmental application decision and says these are additional reasons. And he starts with appeal ground 1. There are 19 appeal grounds. The minister works his way through each appeal ground, setting out the grounds, setting out the responses of the interested parties, and reaching a conclusion in respect of each of them, in meticulous detail. Eventually, he comes to his conclusion, which is at page 2324, which is expressed there. The notion that his decision was irrational, and again, let me not overstate it, is inconsistent with the contents of the document and with common sense. There's a flyer which we see in the heads of argument, apparently not repeated in oral argument. It's at our learned friends' heads of argument, page 45, paragraph 103. It's to this effect, that the minister allegedly conflated the requirements of section 38.3b with item 2A1 of Appendix 1 to the EIA regulations. The minister explains in his affidavit there's no conflation, nor was there any confusion. The provisions are similar. They cover similar ground. The minister dealt with them together, but he distinguished between the two. On the undisputed facts, the minister considered the significance of intangible heritage. Then, at our learned friends' heads of argument, they deal at page 47 with the second proviso to section 38.8. The minister failed to take into account Heritage Western Cape's comments and recommendations. Simply wrong. We've taken you to the portions of the record where the minister goes out of his way to engage with Heritage Western Cape to ask them, what is it that you want? And he gets stonewalled. The notion that they didn't take account of the recommendations with respect is incorrect. It's a recurring theme, milady, but we don't see Heritage Western Cape here to come and explain what their view was. Then at page 38 of the heads of argument on behalf of the appellants, it's the similar type of catch-all phrase that we see, that the decisions were not rationally connected to the information before the decision maker. And the idea that we see expressed is that Hart and Townsend discounted the heritage value of the River Club site because it did not manifest in any tangible form. I've taken your ladyship there. It's simply incorrect. It's wrong. They say it doesn't manifest in any tangible form excepting for the two rivers, but they are at pains to deal with the history of the site, which translates into the intangible heritage significance which we see. And it's our submission, milady, that no case for the review of the decisions of the director and of the minister have been made out on the papers. We also rely on our written heads of argument. I'm not going to read them to you anymore, but they are there for your consideration. We turn then to the submissions of the amicus, They're interesting submissions, but they don't take the matter any further. The amicus concedes that it can add nothing to the facts, but there's also this. The amicus can add nothing to the case as pleaded, as set out in the affidavits in this matter. The submissions on consultation are not based on a case as pleaded. So questions arose from time to time, milady, as to, well, can you show me in the record when consultations commenced? Or can you deal with who might have been excluded from time to time? The first respondent, we understand, wishes to put in a chronology of consultations, and that may be helpful in this regard. But the difficulty is this: where a case is not made out in the founding papers and is not responded to in the answering papers, to then say, well, let's cast about and go and ask ourselves questions like, well, when did it commence? Wasn't it too late? Who might have been excluded? It simply places the respondents in an untenable position. It's not the case which they were called on to meet or which they've sought to meet. Lady, I then turn briefly to certain remaining aspects relating to the requirements for an interim interdict, particularly balance of convenience, and in this matter, the related question of urgency. It is now 11 months since the minister made his appeal decision. Construction on the River Club site commenced in the middle of last year, and considerable progress has been made. The applicants now ask you, on an urgent basis, to grant an interim interdict prohibiting construction on the site. And from the point of view of the provincial authorities, this raises significant concerns, not only for the parties directly involved, but for the people of the Western Cape. What would happen if your ladyship were to grant such an order? Construction would cease, leaving the buildings in a semi-complete state. We've heard about the construction contracts and subcontracts. These would probably terminate with massive negative financial and practical consequences. The workforce would be laid off. And the significant benefits which would follow from the development in terms of employment, broader economic benefits, and the rehabilitation of the river system, the commemoration of the heritage of First Nations people would be lost, probably permanently. So,
Would it
milady,
not have been
from
better for the developer rather to stop the project and not commence with the project, knowing full well that the project is highly contested? Would it not have been better for the developer to concede and rather stop the project? Because they did write to the developer and requested the developer to
It's
stop.
not for the province to speak for the developer.
But you have spoken for the
But-
developer now, because you are now pointing out all the negative aspects or the prejudice that the developer or the project is going to suffer should the court grant the order, and that's why I'm pausing now.
Can I make this
The
submission, milady?
developer decided that they are going to proceed and not accede to the request of the applicants to not commence with the building or
Lady,
with construction.
Sorry. As I've said, it's not for me to speak for the developer, but may I make this submission? May I ask rhetorically, what was the developer supposed to do? There'd been correspondence about this matter.
But
It
you
was
have
contested.
spoken for the
Should he simply
developer?
have stopped and waited? But the other point is this. From province's point of view, it's a broader consideration which would equally apply if the application had been brought as a matter of urgency. In other words, if your ladyship would find There's nothing in the urgency point. It's still a question of the balance of convenience. And the province restricts itself really to saying, you've got to look here at the broader interest. There's ample authority for saying that one should do so in the context of the balance of convenience. One's got to look at the interests of the broader inhabitants of the Western Cape and ask yourself, how does the balance of convenience weigh up here? There is a very real prospect that if this project does not go ahead, there will be a considerable loss of opportunity, economic opportunity, employment, a loss of the heritage advantages which would follow. And that is seriously prejudicial on a broader basis. You weigh that up against the types of considerations that were raised earlier today, and they simply don't weigh up. And that's as far as the province takes it at this stage. We don't engage ourselves in the minutiae of exactly how much the developer might lose at any particular stage, which is not to say that this is not relevant. But from the province's point of view, it's a broader consideration in the interests of the people of the Western Cape. So, Milady, you have our submissions on urgency. We don't abandon those submissions, but they're in our heads of argument.
But, the province's interest would be different to that of the developer. So the interest of the province is the community, the broader public economic growth, more particularly during the COVID-19 period.
That's absolutely correct, my lady, and your ladyship would see.
But I think one still needs to backtrack and not move too far forward. Move back and examine the issue relating to the commencement of the construction in circumstances where the developer and the province knew that it was highly contested. Obviously, the decision was not for well, maybe it's not 100% correct to say that the decision maker's decision was not related to the developer's decision to commence construction, notwithstanding all indications that it's a highly contested development. I would imagine it would be unfair for the court to ask the province to explain that. But the province constantly points out where the prejudice lies and what would happen if this court should come to the aid of the applicants. And that is why the court must pause and ask province. But the developer acted at their own risk to commence construction, knowing that the development was highly contested. So I'm saying one must go back a few steps and then pause there at that particular step before you move fast forward, bulldoze over the whole situation and arrive at the point where one can argue prejudice if the court should come to the aid of the applicant. The developer knew that it was contested.
Yes, one understands your
ladyship. And refused to stop.
Yes, one understands your ladyship's points, but may I make the following submissions? One's got to distinguish between two considerations, those that relate to urgency and those that relate to balance of convenience. One understands the submissions which say, you were told, don't proceed, and you proceeded at your own risk.
Requested not to proceed.
Our response to that, for what it's worth, would be, well, what are they supposed to do? The applicants are tardy in bringing their application. Does the respondent, the developer, simply sit back and wait until the eventual time when the applicants at their leisure file papers? With respect, no. They're entitled to say...
The construction commenced on the very same day. Is it on the same day that the water decision was made? The decision on the water? On the very same day. Isn't that the position? Yeah.
the decision of the minister here was on the 22nd of February. But, Milady, I don't want to lose the point that I'm trying to make, and that is urgency is one thing.
Pointed out issues that impacted on the impact insofar as it...
But if I can follow through on this, Milady.
Yes.
Urgency is one thing. And you would have seen, we take the urgency point as well. You've got what we say in our heads. But your ladyship will distinguish between urgency, where your ladyship may say, well, they proceeded at their own risk, and they can't complain later about the consequences of stopping building. You will distinguish that inquiry from balance of convenience. Of course, part of it is that the balance of convenience becomes even more weighted against the applicants when building has commenced, because there are other inconveniences, prejudices which would follow. But we would say, milady, this. Even if you had to say hypothetically, let's assume that this application had been launched with due expedition, or that your ladyship finds that you're not going to strike the matter from the roll for lack of urgency. That issue is then dealt with. We then still have balance of convenience. And the great deal of the prejudice that the province has referred to would follow in any event. In other words, that you are not going to then have probably all of the benefits that would flow from this development, economic, social, and in terms of the rehabilitation of the area, the commemoration of First Nations people. Those will probably be lost and would probably have been lost in any event, even if there was not an urgency point. And we respectfully ask your ladyship to take that into account. Lady, those are our submissions. If I may just speak to my colleagues for 2 minutes. Lady, those are our submissions. We ask that the application be dismissed. We too ask for costs, including the costs of 2 counsel. We say that's justified. We say that the BioWatch case is not applicable here. This case was not brought to assert any constitutional rights. So we ask for a costs order as well, bearing in mind, of course, that costs are in your ladyship's discretion.